Paul L. Howard, the great DA out of the Fulton County, Georgia area. Strong black brother, much respect to him, being a great example. But when he levied the charges, I knew there'd be some pushback. I didn't think it'd be to this extent. And to be honest with you, from what I'm seeing, it just seems like the forces that have a hand in the media are trying to shift the narrative in a particular direction. Now, I don't have a horse in this race per se, but it's funny how when these things happen, we gravitate to one side because it represents us, right? While I understand at a surface level that as a citizen, the first response you're gonna say is, man, you don't try to push the police or get their taser and do all of that. But remember, there's a certain responsibility and expectation for a law enforcement official when it comes to interactions with the public. So it's not how you would respond to me if I tried to grab your taser. You'd blow my head off. Maybe you'd be justified. But as a police officer, there are other requirements. So folks have to understand the law, and Mr. Howard did a real good job pointing out what evidence he had that would drive him to decide to charge Garrett Rolfe with first-degree murder. Now, does he get convicted of that? I don't know. Put aside the fact that you, as a citizen of America, would have probably shot Rayshard Brooks. Understand that police officers are held to another standard. Now, here's the rationale. The first issue is that Officer Rolfe, according to District Attorney Paul L. Howard, the officers knew that the taser had already been fired twice and had been rendered an ineffective weapon. I believe, in terms of what the DA said during his presentation, that this information may have been relayed verbally. So if they said from their part that they thought, knew that there was nothing in the taser, it doesn't help out their argument in terms of saying, well, I thought that he was going to shoot me in the eye, for example. It's like, that nothing's really going to happen, but you decide to take it to a deadly force sort of level. The second issue is that there are two foundational cases that create the precedent and the rationale for, from a legal standpoint, for DA Howard. One of them in particular, Tennessee versus Garner and Graham versus Connor. These are two fascinating cases. In Tennessee versus Garner, the Supreme Court held that deadly force cannot be used against a fleeing suspect. Now, this is a case that transpired in October of 1973 in Memphis, Tennessee, in which officers were called onto a scene of a possible burglary. And when one of the officers approached the back of the house, Garner proceeded to begin to try to jump over the fence. The officer screamed, "Stop." Garner kept going. Officer pulled out a gun, shot Garner in the back of the head, and he died shortly thereafter. After this transpired, Garner, who was a 15-year-old, by the way, his father filed a 1983 civil rights suit on his behalf. It's at that point that the district court found that the officer's actions, as well as the Tennessee statutes, were constitutional. The Sixth Court of Appeals reversed the decision, and the Supreme Court granted cert. In this case, deadly force should not be used against a fleeing suspect unless that force is to prevent the suspect's escape or there is probable cause to believe that that suspect is a threat to the officers and others. A threshold matter, the courts went on to say that apprehending a suspect by reasonable force is a Fourth Amendment seizure matter. And here's the most important component that I think you should really try to just lodge into your head, is that the court noted that if someone is fleeing and they don't have a weapon, you cannot shoot them. This is according to the Supreme Court, under the totality of circumstances. Now, there is a caveat if the suspect seems to be posing a threat to the officer and others. Now, that's where, again, it can be up to debate, if you will, or whether an attorney can argue that component of this particular case law in a way that highlights that aspect. I mean, again, that final move with the taser could have been perceived to be problematic, to say the least. But that is a foundational case. Now, this one's very important. It's the matter of Graham versus Garner. In a nutshell, it's a case where a young man that was actually a diabetic went over to the corner store around his house and jumped out fast, saw that there was a long line, jumped back in the car. Police officers watching the whole time. They pulled up on those two dudes, got them up out of the car. Him blown up pretty badly, and he ended up breaking a foot, scratch, nicks and dings all over his body. Again, just a simple interaction that could have been avoided. But anyways, that transpired. The attorney filed a civil rights lawsuit on behalf of Graham against Officer Garner, and at that time, according to the attorneys on the case, the courts were using the standard based off of the 14th Amendment, which is the standard of malicious intent, or in some instances, the 8th Amendment, which is the clause protecting against cruel and unusual punishment. Both of these laws essentially required that you prove that the officer had malicious intent, which is difficult in practice. But by using the 4th Amendment, it lowered the bar, if you will, by proving that the officers acted unreasonably. So that's the standard there. And one can say that in that scenario, it seemed like Officer Rolfe acted unreasonably in letting off those rounds, 3 to be specific, 2 straight through the back and 1 that actually hit a bystander's vehicle in a crowded parking lot. In terms of other reasons why DA Paul L. Howard is pursuing other charges against former Officer Rolfe, it's because of an excited utterance on the part of Officer Rolfe. He mentioned this during his presentation. Apparently, Rolfe screamed out, "I got him." Now, is that appropriate? I don't know. Furthermore, Atlanta PD fired Rolfe, so they set the stage to essentially say that Rolfe did have some sort of culpability in what transpired and may have acted egregiously that night. They didn't immediately inform Brooks of his DUI, and that was a misstep. And then I think something that can't be overlooked is the fact that, again, there was a vehicle in that parking lot that was shot by Officer Rolfe. And then the fact that, and if this is true, this how do you justify this? And it just seems to speak to the cruelty, the cruelness, especially all things considered, because George Floyd just happened. But apparently Rolfe kicked Brooks as he was dying there on the floor. I mean, there's no way to get around that, right? And I hope that compassion, again, that you and anybody else that might be a potential juror out there showed was genuine, because that shouldn't happen to anybody, whether they, again, it's one thing to shoot someone for taking your taser and doing all of that, but you didn't kick them afterwards. Again, remember, it's a higher standard for police officers. And last but not least, and I think this is the most fascinating part about all of this, we'll see how it plays out, because his lawyer is claiming that that's not going to happen. He's not going to testify. But the sheer fact that Brosnan apparently, even if there's a potential for him to testify, that means that he has been debriefed and he's shared some information about either the frame of mind that Officer Rolfe was in,